Tariffs in Chains: How America's Highest Court Rewrote Donald Trump's Trade Playbook. In politics, power is most seductive when it appears effortless. For years, Donald Trump cultivated precisely that illusion in trade policy. With a post on social media, a late-night press briefing, or a few sharp words on Air Force One, tariffs appeared and disappeared like weather fronts. Markets trembled. Governments recalculated. Businesses scrambled. Then, on February 20th, America's Supreme Court quietly dismantled this illusion by rejecting Mr. Trump's use of the International Emergency Economic Powers Act, IEEPA, to impose sweeping tariffs. The justices did more than strike down a legal argument. They restored a constitutional boundary that had been blurred by executive improvisation. In doing so, they opened a new chapter of uncertainty, less theatrical than before, perhaps, but no less consequential. The ruling marks the end of tariffs on smartphones. It also reveals how fragile Mr. Trump's economic nationalism has become. Just as the midterm elections approach, the end of emergency economics, the court's judgment was unusually crisp. Writing for a rare cross-ideological majority, Chief Justice John Roberts reminded the executive branch of an elementary constitutional fact: the power to tax and tariff resides with Congress, not the President. IEEPA, enacted in 1977 to manage genuine national emergencies, allows presidents to regulate financial transactions and trade under extraordinary circumstances. It does not, however, mention tariffs. Not once. Mr. Trump's lawyers had attempted to stretch regulation into taxation, an act of interpretive gymnastics that the court declined to applaud. The ruling therefore closed a loophole that had become central to Mr. Trump's governing style. Emergency had come to mean whatever inconvenienced the White House at a given moment. Trade deficits were rebranded as crises. Diplomatic disputes became existential threats. Legal restraint yielded to political expediency. Now, that latitude has vanished. As the Washington Post observed, the president can no longer rewrite tariff policy with his thumbs. The age of impulsive trade shocks is over, at least in its most flamboyant form, the rise and fall of the economic king. For Mr. Trump, tariffs were never merely technical instruments. They were symbols of authority. Stephen Greenhouse of The Guardian once likened him to a self-styled king of the economic jungle, wielding duties and exemptions as tools of intimidation. Countries were rewarded or punished according to their perceived loyalty. Companies lobbied, pleaded, or complied. Diplomacy blurred into transactional theater. This approach had three political advantages. First, it created visibility. Tariffs are tangible. They can be announced, quantified, and dramatized. Second, they fostered personalization. Policy became an extension of Mr. Trump's will. Third, they generated perpetual motion. Each new levy created another confrontation, another headline, another rallying cry, but this strategy rested on legal sand. Emergency powers were never designed for permanent economic warfare. The Supreme Court has now confirmed as much. In doing so, it has demystified the presidency. Trade policy, once portrayed as a personal weapon, has been returned to the realm of procedure. De-escalation without stability. Economists welcomed the ruling cautiously. Gregory Dacko of EY Parthenon described it as a de-escalation rather than a reset. That distinction matters. The court has weakened one instrument, not the entire arsenal. Indeed, uncertainty remains embedded in three areas. First, durability. Tariff reductions can be reversed under alternative statutes. Second, substitution. Other legal provisions, sections 201, 232, 301, and even 338 of trade law, remain available. Third, legacy. Existing duties may yet provoke years of litigation. The message to investors is therefore ambiguous. The worst excesses may have been curtailed. But volatility has not been eliminated. Markets are no longer governed by whim. They are governed by paperwork. Plan B, rule-bound nationalism. Mr. Trump's response was immediate and revealing, within hours of the ruling. He invoked Section 122 of the 1974 Trade Act, imposing a 10% tariff on all imports, later raised to 15%. This provision allows temporary levies during balance of payments crises, but only for 150 days. It is nationalism under supervision. Section 122 is not designed for grand strategy. It is a holding measure, intended to buy time while more complex investigations proceed. During those months, the administration must justify itself, collect evidence, and withstand scrutiny. This is precisely what Mr. Trump had sought to avoid. Other statutes impose similar constraints. Section 232 requires national security findings. Section 301 mandates investigations into unfair practices. Section 201 demands proof of serious injury. None permits instantaneous action. Plan B, in other words, is slower, narrower, and legally fragile. Power remains. But it must now cue popularity and the politics of pain. Tariffs are taxes. Politicians often forget this. Every duty imposed at the border is eventually paid by someone: importers, retailers, consumers, or all three. The costs are dispersed, delayed, and difficult to trace. But they accumulate. Polling suggests that voters have begun to notice. A survey conducted by ABC News in partnership with Ipsos found that 64% of Americans oppose Mr. Trump's tariff policies. Only 34% approve. This is remarkable. Trade disputes are usually abstract. They rarely dominate kitchen table conversations. That they now provoke majority resistance suggests a shift in perception. Inflation, supply chain disruptions, and rising consumer prices have made trade policy tangible. Protectionism no longer feels patriotic. It feels expensive. Ed Gresser of the Progressive Policy Institute has therefore questioned the political sustainability of Mr. Trump's approach. The tariffs, he argues, are deeply unpopular. They mobilize opposition more reliably than support. As midterms approach, this matters. $175 billion in legal limbo. Perhaps the most destabilizing consequence of the ruling lies not in future tariffs, but in past ones. By declaring IEEPA-based duties unlawful, the court has cast doubt on roughly $175 billion in collected revenue. Whether and how that money will be returned remains unclear. The justices declined to specify a refund mechanism. Lower courts must now interpret and implement the decision. The U.S. Court of International Trade has already claimed authority to order repayments. Litigation will be vast. Retailers, manufacturers, and importers have prepared accordingly. Costco, for instance, filed suit preemptively, seeking full reimbursement. Theoretically, refunds should be manageable. Payments were recorded by product and shipment. In practice, tracing responsibility through layered supply chains will be laborious. Mr. Trump has warned that disputes could drag on for 5 years. He is probably correct. Thus, the ruling has created a fiscal time bomb. The Treasury may yet face claims equivalent to a major stimulus package, one distributed by judges rather than legislators. Institutions strike back. Beyond trade, the ruling represents something larger: institutional reassertion. For years, Congress ceded economic authority to the presidency. Emergency statutes, trade laws, and delegations of discretion accumulated. Lawmakers preferred convenience to responsibility. Mr. Trump exploited this abdication. He treated ambiguity as license. The court has now pushed back. By insisting on textual fidelity and constitutional hierarchy, it has rebalanced the separation of powers. Congress must legislate. Presidents must execute. Emergencies must be genuine. This may not sound revolutionary. In modern America, it is. The decision reflects judicial fatigue with executive maximalism, not only under Mr. Trump, but under his predecessors. National security, public health, immigration, and now trade have all been arenas of expanding presidential authority. Courts are increasingly skeptical. In this sense, the tariff ruling is part of a broader constitutional correction. Global reverberations. America's trading partners are watching closely. For years, they struggled to interpret Mr. Trump's signals. A tariff announced today could vanish tomorrow. A threat issued in anger might become policy. Negotiations were conducted in public, in fragments, and in bursts. The court's intervention introduces predictability. future duties will require procedures. Challenges will be possible. Timelines will lengthen. Diplomacy will regain relevance, yet foreign governments should not confuse order with benevolence. Mr. Trump remains committed to economic nationalism. He has merely been forced to practice it within constraints. Trade conflicts will persist. They will simply be slower, more legalistic, and more bureaucratic, for allies and rivals alike. This is a mixed blessing. From volatility to friction, the transition from IEEPA to statutory trade tools marks a shift in risk. Previously, firms faced volatility, sudden shocks, abrupt reversals, and unpredictable escalation. Now they face friction.